I'm now pleased to introduce the witnesses for our second panel for today's hearing. Our first witness will be Mr. William Pascrell, Jr., representing the 8th District of New Jersey, elected to Congress in November '96. I think everybody knows about his record. He introduced H.R. 1927, Accountability and Deferred Prosecution Act of 2009, this past April 2nd. Congressman, would you please proceed with your testimony?
Mr. Chairman, I'm honored to be here today and thank the entire committee and ranking member. We're not here to eliminate deferred prosecutions. That was no part of the bill says that. We are simply here to elevate their application. Every citizen in this esteemed committee should understand how deferred prosecutions have become part of the justice system. As I study this issue, Mr. Chairman, I believe that deferred prosecutions are related to the larger issue of corporate prosecutions in the post-Enron era. Well, what I come to realize is that these agreements are actually even more relevant to the type of corporate malfeasance that cost millions of Americans their jobs. They're gone. Those jobs are gone. I do not know the prior witness what jobs he was talking about. They led our nation to the brink of the greatest economic crisis since the Depression. Quite simply, corporate greed, collusion, and illusion have become legion. The executive branch and the Congress have, for the most part, stood aside, witnessed a significant collapse of oversight, justice, and professed American values. I would contend, after examining the volumes of evidence before us, that the sentinels at the gate, a fair number of U.S. attorneys, have been handmaidens to the fleecing of our citizens. However, as we saw in the Zimmer case, older Americans were the ones who suffered the physical and mental consequences of bribery and fraud. We witnessed the bribery of physicians so that they would advocate for a specific prosthetics device regardless of whether it was defective or not. Not one person before us today on the first panel talked about the victims. These perpetrators of Medicare fraud are the lowest of the low, in my opinion. And yet, because they entered into a deferred prosecution, these corporate criminals have never had to even admit guilt to the consumers they cheated. And thanks to Mr. Christie, they never will. Mr. Chairman, and the members of this committee, there's been an erosion of confidence, as Mr. Dullahan talked about earlier, not only in the financial system, but in the justice system, which failed to bring the bad actors to justice. Pay a fine, avoid jail. Promise you'll do better next time, and no one gets prosecuted. The fine simply becomes the price of doing business. In fact, many corporations, that's part of their business brief. The captains of corporate America who did our nation wrong look to the very justice system that's supposed to protect citizens to bail themselves out. We're here today seeking legislation to help right the ship of justice. This goes way beyond one conflict of interest concerning a $52 million no-bid contract. Mr. Christie and Mr. Ashcroft should not flatter themselves. Our bill, the Accountability and Deferred Prosecution Act of 2009. Yes, Mr. Johnson, what could be wrong with that? Accountability. You're right. It simply brings accountability and transparency to this process for the first time. I want to literally show all of you just one example of why we need transparency on this issue. Here are the files of one monitor, Deborah Wong Yang. These are files we obtained from the Senate Committee on the Aging, which held its own Medicare fraud investigation in the case in question. This bill from DuPai Orthopedics, sent to DuPai Orthopedics, which had former U.S. Attorney Deborah Yang selected as its monitor, is about 200 pages long. I've read every page. And is so detailed that it even documents every time Ms. Yang had charge a cab fare, which is standard billing practice for law firms. However, the bill sent to Zimmer Incorporated by Ashcroft, the Ashcroft Group, which charged many millions more in expenses, does not include any information about the services provided. It gives us no information whatsoever. No billable hours, no reimbursable expenses. In fact, it's just one page bill listing the total amount due. The bank information about where to wire the bank, I think that's fitting, by the way, and nothing more. This is a ransom note, not a billing statement. Please examine both of them. You come to your own conclusion about transparency. It should come as no surprise that the executive branch will always prefer to alter its own procedures at its own pace. But as members of Congress, I believe we have a solemn responsibility to oversee these practices and take corrective action when it is called for. The Zimmer case merely highlights the lack of oversight of deferred prosecutions. In this case, there existed a clear, outright conflict of interest as Mr. Christie set out to hire his former boss, Attorney General Ashcroft. We know at least 120 different deferred prosecution agreements, and as the GAO pointed out, many of them were undertaken by federal prosecutors who had the diligence to seek a transparent and fair process for entering into these agreements and selecting monitors. We're not just talking about the manager. We're not talking about a manager of a baseball team, and I happen to be playing on that baseball team. I'm talking about the manager of justice in the United States of America who left his position and was hired by one of the people on his team to do this job. Mr. Christie and many of his acolytes will trumpet the deferred prosecution system they expanded as a fail-proof method to cleanse corporations. To them, I need cite only one example, AIG. 2004, 2006, 2 deferred prosecutions. And it worked well, didn't it? This former insurance giant, which is now synonymous with corporate greed and public deceit, received 2 deferred prosecution agreements and paid a monitor $20 million. For what? In accepting the deferred prosecution, Mr. Greenberg, now disgraced, too late, horse is out of the barn, this comprehensive deal brings finality to the claims raised by the SEC and the Department of Justice. The role of an independent consultant complements our own transaction review processes. We welcome this enhancement, he said. Today, the wreckage of AIG sits asunder the ruined dreams and hopes of so many Americans who literally had their planned futures taken away from them. I wonder how many of those lost their jobs and lifelong savings who would say that the deferred prosecution system did its job. Mr. Chairman, thank you for listening. I have more to say, but time is of the essence.
Thank you, sir. We've got 8 minutes to the next vote. Our next witness would be